But they've got to have representation or warranties that things are accurate and valid, which is going to take a lot more manpower on their part. And if they don't provide these things, it is going to be the basis where you could presumably get things bounced out of court. Hey everybody, John Skiba here from the Consumer Warrior YouTube channel. And in this video, I'm going to do something a little bit different. We're going to do a deep dive in the recent order and sanction that was issued by the Consumer Financial Protection Bureau against junk debt buyer Portfolio Recovery Associates. If you are being sued by Portfolio Recovery Associates, you want to stick around here because we're going to show you how you can use this order as a very powerful tool to possibly get your lawsuit thrown out. If this is your first time here to my YouTube channel, please go ahead, click subscribe, check on that little bell. That way you'll be notified each and every day when we put out new videos that'll help you deal with your serious debt issues. All right, let's talk about Portfolio Recovery Associates. The shorthand form is PRA. PRA is one of the largest junk debt buyers in the United States. They purchase debt on a huge volume from credit card companies, medical bills, all that kind of stuff. They pay pennies on the dollar, and then they file lawsuits against consumers with the hopes of getting a judgment so that they can then garnish your pay, garnish your bank accounts, and basically make life really difficult. Recently, the Consumer Financial Protection Bureau, CFPB, they issued an order or a sanction against Portfolio Recovery Associates because of some of the illegal tactics they take when attempting to collect debts. Now, the Consumer Financial Protection Bureau is a governmental organization. They're tasked with overseeing debt collectors and debt collection type things and really representing consumers and protecting consumers in these types of transactions. Now, this is not the first time. This is not Portfolio's first rodeo when it comes to being sanctioned by the Consumer Financial Protection Bureau. They actually sanctioned them pretty heavily back in 2015, and they sanctioned them for the exact same things that they got caught doing. Now, here in 2023, they're doing the same exact stuff. And so they issued a pretty hefty sanction against them. They fined them $24 million for doing things like suing on debts that were outside the statute of limitations, for suing on debts that they didn't have enough documentation to support what it is that they were alleging in the lawsuit, and a whole other laundry list of things. And so what I wanted to do today is go through the proposed order that was submitted by the parties to the court for signature, and then talk about how you can use that in your lawsuit. So the first thing we'll do is go through and kind of show what it talks about, and then at the end of the video, I'm going to show you how you can use it in your specific lawsuit to help yourself get a better result. So the first thing we're going to do here is, if you need information, documentation, all that kind of stuff, you got to go over to the Consumer Financial Protection Bureau. Their website is consumerfinance.gov. They have a ton of information. You can actually read what I'm showing you here, which is their press release. It was issued on March 23rd, so just recently issued. And they talk about what they did as far as the penalty. Again, here we're seeing $12 million penalty, as well as an additional $12 million to be deposited for this victims relief fund. So $24 million, which, you know, a company like Portfolio Recovery, they're a huge company. They were showing that PRA here, their net income for 2021 was $183 million. So they make a lot of money, but I mean, this is a good 20% plus hit of their net income. It's definitely going to sting a bit. So let's talk about what happened back in 2015. So 2015, the CFPB issues an order, just like they did through the courts here. And this is they outline in this press release what happened here. They said that they were prohibiting them from collecting debts without a reasonable basis, selling debt, threatening or filing collection lawsuits when they didn't have any intent to prove the debt or the ability to do it, filing false or misleading affidavits in debt collection actions, making false or misleading representations, and collecting or suing on debt that's outside the statute of limitations. Well, so what they have found is that, fast forward now to 2023, basically they're doing the same stuff, that they really didn't change their ways much. Again, they're saying here that they are, in that time period since then, that they're making misrepresentations about unsubstantiated debts, threatening consumers with potential legal actions, and initiating debt collection lawsuits without offering or possessing the required documentation, misrepresenting that they would provide certain documents within 30 days to consumers, collecting on time-barred debts without making the required disclosures. So not only were they trying to collect on debts that are outside the statute of limitations, the Fair Debt Collection Practices Act requires that they put a label on it. They're sending you a letter saying, hey, you don't have to pay this, it's outside the statute of limitations, but they weren't doing that, and then just filing lawsuits on debts that were outside the statute of limitations. So what the Consumer Financial Protection Bureau did is they went to the court, the federal district court, and the parties entered what's called a consent order. Now, I'm going to try and share this with you, the actual order from the court proceedings, so that we can go through it together and you can kind of see how it is that you would use use this to your benefit. This is the actual document that was submitted by the parties to the court. This is the stipulated final judgment and order. You can see at the top here, we have the case number. This was in the United States District Court, Eastern District of Virginia. We have the case number here, which is 2:23-CV00110. JKW, that's usually the judge's initials who's handling the case. This was filed just on March 23rd. Now, the one thing to know initially is that this is a stipulated order of final judgment. And what that means is that the parties have agreed to this. The Consumer Financial Protection Bureau and Portfolio Recovery Associates, they've agreed to this final judgment and they've submitted it to the court for approval. We can see when we look down here on the last page that it's been signed by one of the attorneys for the Consumer Financial Protection Bureau as well as the attorney for Portfolio Recovery Associates. So Portfolio Recovery Associates, I'm sure they don't like this, but they're in agreement with the CFPB has said. You'll notice with this copy, there's no signature for the judge yet. The judge has not signed this. It's been submitted to the court. That means it's not a final order. So that's my only little caveat in this. When the parties agree on something like this, unless there's something just totally out of bounds, the court's going to sign off on it. So we should have an official signed order, and I'll provide a link to this down below as well. But we'll provide you a final copy because you'll need the final version signed by the court to be able to use it in your lawsuit if you're being sued by it. So I'm going to go over just the highlights. I mean, this thing is 39 pages long. We're not going to go through all of that. But like I said, the first thing you need to understand, this is the Bureau, the CFPB, and the defendant, Portfolio Recovery. They have agreed to this entry of this judgment. Now, the first section has a lot of definitions in it, and it's important to know the 2015 order that references, that's the one I was telling you about for Portfolio Recovery, got their hand slapped back in 2015, 8 years ago, and they're still continuing to do this. And if you read this, you're going to have to read through the definitions because they are important. You'll see this abbreviation throughout it called the OALD. This stands for Original Account Level Documentation. These means that these are original documents from the original creditor. We're talking transactional history created by the creditor, the creditor's agent, and a copies of judgments if it's already been awarded in a lawsuit. So they've got to have this original account level documentation before they're going to be able to do any types of collection on any debts that they have purchased between the year September 9th, 2015 and 60 days after the effective date of this order, which is essentially now. They cannot collect on any debts that they purchased during that time period unless they have specific representations and warranties as to the accuracy or validity of the debt, a commitment to provide the original account level documentation during the time period in which the defendant is collecting the debt, unless the defendant possesses within 90 days of the effective date of the OALD, reflecting the consumer's name and the claimed amount of debt, excluding any post-charge-off or post-judgment payments. So essentially, they've got to be able to commit to provide you with that documentation, but they've got to have representation or warranties that things are accurate and valid, which is going to take a lot more manpower on their part. And if they don't provide these things, it is going to be the basis where you could presumably get things bounced out of court. Further, they have to make a commitment to providing any individual, it says commitment from the seller to provide the following documents for any individual debt in the portfolio within 90 days of closing or 60 days of the defendant's request. And again, it's this original account level documentation that they're requiring, that they've got to be providing it to you. And again, they've got to provide representations. I'm assuming this is going to be an affidavit, but representations and warranties sufficient to establish that each debt is accurate and valid. They further they are barred from collecting on any time-barred debts through litigation, arbitration, or any other legal collections. And if they're going to file a lawsuit under a breach of contract theory, which is what they always allege, they have to provide within 30 days of effecting service. So 30 days within serving the complaint to the summons, they've got to provide you the contractual terms and conditions governing the debt to the consumer. This is important because here on the channel, a lot we talk about the motions to compel arbitration. The arbitration clauses are going to be found within these original contractual terms. So that's an important thing that they're going to have to provide you without you even asking. And so my recommendation, if you have a lawsuit or even collections from Portfolio Recovery, check out the link below. I'll put this in here so you can download it, take a look at it, and review it. Again, it's 39 pages long, so it's not a short read. It's going to take you a little bit of time, and there's a lot of information here that can be very helpful. And this just goes further to talk about the penalties. They have the $12.8 million payment, and then they also have another $12 million penalty. And so if you've been affected by a portfolio in the past, you may be entitled to receive payments for some of these funds. They're not only a penalty, but some of them are going to be direct payments to consumers who've been impacted by this. So the important thing to remember with this is if if you have been sued by portfolio recovery associates, you can use this, not only get information, but you can use it to tell the court, like when they're trying to have documents admitted under 803.6, which is the hearsay exception to the business records exception to the hearsay rule. One of the requirements is that they have to show that there's nothing inherently untrustworthy about the documents. Well, if you have a company that's been hit in 2015 and now again in 2023 for the exact same things over and over again, that brings into question whether there is reliability in their documents and if the courts can really trust what it is that they're alleging. So again, I'll put a link there. If you're in the state of Arizona and you have one of these cases, feel free to my information below. I do a free consult. We can talk about it if it's something that we could get involved with and help you. Otherwise, check out the link below to get a copy of the consent order. I'll update this once we have the final one from the judge, but take a look at this, see if this can be of help to you. In 2015, I can tell you every case I had with portfolio recovery associates, I submitted a copy of this order with my initial disclosures, with motions for summary judgment in my response, just to show that, look, court, we're dealing with a bad actor here. And now we're showing that they're a repeat offender and they've been sanctioned heavily by the government for continually just ignoring the rules and really violating the law. So hopefully that's helpful. I appreciate you checking in today. Again, check out my information below. And if we can be of help, feel free to reach out. Thanks for watching.